Good evening, and welcome on behalf of the Lumen Christi Institute. Lumen Christi was founded in 1997 by Catholic scholars at the University of Chicago, and its mission is to make the Catholic intellectual tradition a living dialogue partner at the university, within the academy, and in our broader society. My name is Tom Donnelly. I am an associate judge in the Circuit Court of Cook County and president of the Catholic Criminal Justice Reform Network, an initiative of the Lumen Christi Institute. Tonight's program, Cruel But Usual, Solitary Confinement's Tortured History, is presented by the Catholic Criminal Justice Reform Network and is co-sponsored by the Catholic Mobilizing Network. The Catholic Criminal Justice Reform Network is hosting a continual series of these webinars, public events at universities around the country, 2 academic conferences, several dialogues with those impacted by our system, and culminating in an inaugural national conference in April 2022 at Georgetown Law School. Upcoming events of the Catholic Criminal Justice Reform Network include 2 hybrid programs. At Seattle University and streamed online, we are hosting a roundtable discussion a week from today on justice and peace, a radical reconsideration of public safety. In 2 weeks, Thursday, October 14th, we will host a hybrid program at Loyola University Chicago on The Rage of Innocence by Kristen Henning, addressing the challenges facing court-involved youth. Please visit lumenchristi.org to learn more about these events and share them with others. In all our work, the network asks how we might change our courts, corrections, and community if we took the dignity of the human person seriously. Tonight, we ask that question in the context of solitary confinement. Not one to mince words, Pope Francis has described solitary confinement as torture, employed under the pretext of offering greater security to society or special treatment for certain categories of prisoners. We will now hear from 3 scholars who will talk about solitary confinement from both a contemporary and historical perspective. Questions may be submitted during the panel presentation by participants in written form via the Zoom Q&A box. Andrea Armstrong is the Law Visiting Committee Distinguished Professor of Law at Loyola University, New Orleans. She holds a JD from Yale Law School, MPA from Princeton University's School of Public and International Affairs, and a BA from New York University. A leading national expert on prison and jail conditions, her research focuses on the constitutional dimensions of prisons and jails, specifically prison labor practices, the intersection of race and the conditions of incarceration, and public oversight of detention facilities. Her research on deaths behind bars has recently been featured in the New Yorker magazine and on MSNBC. In her 2019 Louisiana Law Review article, The Missing Link, Jail and Prison Conditions in Criminal Justice Reform, she explains why prison and jail conditions are an essential element of broader criminal justice reforms. David Shapiro is clinical professor of law at Northwestern University's Pritzker School of Law. He graduated from Harvard College and Yale Law School. He clerked for Judge Edward R. Becker on the Third Circuit. Having devoted his career to fighting for racial justice and civil rights, first at the ACLU National Prison Project, and since 2012 as a MacArthur Justice Center attorney, and a Northwestern law clinical faculty member, he founded and directs the Justice Center's Supreme Court and Appellate Program, which helps ensure that people subjected to police brutality, indecent prison conditions, and wrongful convictions have the best representation possible in appellate and Supreme Court cases. In 2019, he published a groundbreaking study in the Harvard Law Review, Solitary Confinement in the Young Republic. John Stinneford is the Edward Rood Eminent Scholar, Chair, and Professor of Law at the University of Florida Levin College of Law. He holds a JD from Harvard Law School, an MA from Harvard University, and a BA from the University of Virginia. Before joining the Florida faculty, he clerked for the Honorable James Moran of the United States District Court for the Northern District of Illinois, served as an assistant United States attorney, and practiced law with Winston & Strawn in Chicago. He researches, teaches, and consults in the areas of legal ethics, criminal law, criminal procedure, and constitutional law. His work has been cited by the United States Supreme Court, several state Supreme Courts, and federal courts of appeal, and numerous scholars. He has authored several articles and book chapters examining the Eighth Amendment jurisprudence surrounding the use of solitary. Professor Armstrong will talk first, followed by Professors Shapiro and Stinneford. Professor Armstrong?
Thank you so much for inviting me to participate in this evening's discussion around solitary confinement. It is a critical issue in our prisons, jails, detention centers across the nation. And what I hope to do today is to share some of the context that we see around solitary confinement, including some research that I have recently completed or published, and citing to some other recent work around contemporary conditions of solitary confinement. There'll be three basic areas that I'll cover today. One is just an overview of solitary confinement and populations, including implications for race. Second, I'll take you through some of the projects that I've worked on through photos and videos of different solitary environments here in Louisiana and also in Norway. And then third, I'll briefly talk about the healthcare challenges and deaths that we see resulting when people are placed in solitary confinement. First, we have to acknowledge how little we know. So we don't know very much about how many people are held in solitary confinement in prisons, jails, and detention centers. We are beginning to get a picture of what that looks like in prisons. But there's a reason why we don't know very much. And that's because the law in lots of various forms has shielded what happens behind the walls from the public gaze. And so one issue that I think transcends both solitary confinement, but also thinking more broadly about prisons and jail conditions, is thinking about transparency and accountability for what happens behind the wall. They are unique spaces where individual rights are at their lowest ebb, but we know that government power is at its highest apex. Here's what we do know about solitary populations. And this is from a Yale Law School project, which is through the Lumen Center, through a partnership with the Association for State Correctional Agencies. And they distribute a survey only to prisons, right? But what they get is they distribute these surveys and then receive that information back. And this is based on approximately 32 responding jurisdictions. So what we know is there are at least 55,000 people in the United States who are in solitary confinement conditions. And they use the internationally accepted definition through the Mandela Rules of 22 hours a day for a period of 15 days. And in some cases, that extends far longer. Other groups will define solitary confinement as a lack of meaningful human contact, right? Without referring necessarily to the number of hours. You should note that these numbers don't include what happens in our jails. It doesn't include our juvenile detention centers, nor does it include any other form, any other carceral space, for example, such as immigration detention centers. But here is one thing that stands out, and it's something that I wrote about in an article for the University of California, Irvine, thinking about discipline and thinking about race and how that happens and works behind bars. And in that article, what I do is I look at both explicit but also implicit bias, implicit racial bias, and imagine how that might play out in terms of disciplinary decisions that we see in prisons and in jails. And it turns out that it may in fact be operating the way that we think it might. So we see an overrepresentation, particularly of African Americans in solitary confinement, not only because they are disproportionately impacted relative to their general shares of the population by incarceration, but even when we take into account their disproportionate representation within prison populations, they are still more highly represented within the solitary confinement populations. And so here on this slide, you can see that they are 40.5% of the total custodial population, but it looks like that they are 43.4% of the population that is held in solitary confinement. You should also note the reverse for white populations, where it would appear that they are underrepresented. And so the first thing that I hope you take away from thinking about populations and solitary confinement is that it is disproportionately compounding other types of structural and systemic issues that face racial minorities here in the United States. The second part of this presentation is to really take you through a couple of different spaces. And so I've had occasion to visit Oslo prison in Norway. I've visited Camp J, which was the primary solitary space at Louisiana State Penitentiary. And then I've also worked on a documentation project for the House of Detention, which is a New Orleans jail, and was a building that was part of the jail. And that was closed in 2012. And through those 3 different trips, I've been able to take pictures and want to share some of those spaces with you. And so here we have what is a standard solitary cell. So here on the left, you see Oslo prison, Norway, and there they have, under their kind of law, culture, and constitution, an emphasis on individual privacy. And so the cells there are designed as individual cells, and yet the result can often be the lack of meaningful human contact with others. On the right, you see disciplinary segregation at Angola. So what we know about solitary is that it can take a number of different names. It could be called restrictive housing. It could be called disciplinary segregation, administrative segregation, in some cases, protective custody. Some call it transitional segregation. And so it takes a lot of different names, but what you'll see through these pictures is it looks consistently similar no matter which facility we are looking at. So here is a few more pictures of Oslo of what looks like a standard cell. Notice that the door is absolutely solid with only one little viewpoint right here, which the correctional officer is holding. On the front of that solid door may be magnets. So here is a magnet indicating that the person inside has a gang affiliation, according to the prison authority. And so these doors are almost always closed. When we visited, they talked about how that opening may be open, but because of the emphasis on privacy, those doors remain closed. Next, I wanted to share what outdoor recreation might look like for a person who's in solitary. So on the left is essentially a cage that a person who is in solitary is allowed to access. In this case, they were allowed to access that once a week. And I worked closely with a man named Glenn Ford, who was a close friend of mine before he passed. He had spent time on death row. He was wrongfully convicted. He was on death row for close to 30 years. And for the last 7 years of his confinement on death row, he actually never left his cell other than for medical or legal visits, but he never went outside. And in part, one of the reasons why he never went outside is that he talked about not being treated like a dog, and that he refused to go into a dog pen in order to go outside. And at that time, the death row was all solitary confinement. On the right, you see something very similar. This is the space where people are allowed to have their outdoor exercise or recreation, and that is in Oslo prison, Norway. But note, again, it's completely fenced in, limited space. In Oslo prison, that one has shade, but you don't have access to water or restroom facilities, for example. On the left, there is no shade, no water, or restroom access, meaning if you have any of those needs, you're going to forfeit the time that you actually get to spend outside. I'd like to show you a brief clip of what of the psychiatric unit that is on the house, it's in the house of detention. And what you'll see here is what a standard solitary cell looks like. This is house of detention, central lockup side, 10th floor, psychiatric wing, last cell. So what I want you to note here is the lack of visibility. So for example, the guard station is at that far portion of the hall that you just saw, right down there. And so if the guard is not actively walking the halls, these last cells, it's impossible to see what's happening within them. Many of the people who are in solitary, as I'll discuss a little bit more later, have significant mental health needs. And therefore, frequent observation, communication is essential for their well-being, and also to make sure that they are safe where they are. This is that same unit, but this is the perspective from inside the walls, inside the psychiatric cell. And so I'm standing there virtually in the middle of the cell, and you can see how little space it is. This actual cell measures 6 feet by 10 feet. And so your head, if you're sleeping on that side of the bunk, is literally a foot from the toilet bowl. And you are confined in that space for the majority of time, remembering that you can only exit. Usually it would be for a minimal amount of time per day, for a shower, for a visit, for a legal visit, or outdoor recreation. And you have to fit all of those activities within your allotted time out of cell. Many of these spaces are also used as restraint cells. And so here on the top right, you'll see a picture of a restraint cell that's used in Oslo prison. And notice how you'll have restraints here on the ankles as well as up at the top. And then you'll have a belt here that can go across the belly or waist. On the left, we have a short clip to show you what a restraint bed looks like in the New Orleans jail. And there they have a metal bar that goes around the outside of it, to which that they can tie shackles. So you can be in 4-point restraints, which would be one for each wrist and one for each ankle, or you could be in 5-point restraints, which would include a belt across the belly. This is HOD, CLU, north side, first cell and restraint cell. So what I want you to notice here is that there are no restrooms in that space. And in fact, when someone is restrained, they actually have to wheel in what is essentially an accessible toilet, which is essentially a toilet seat with a bucket that is there. And this is their view for as long as they are restrained there. That becomes a significant issue. We've had a number of deaths, both in this facility as well as others, where people were restrained for too long, developed blood clots or infections from the restraints, and subsequently died. There's another form of solitary, which are called isolation cells. So here on the right, this is an isolation cell in Norway. Here is essentially a hole in the floor with 2 blocks there to perch upon to use as a toilet. There's no running water in that facility or in that space. It is actually an enclosed space within another enclosure. And so depriving you of kind of noise, the ambient noise that happens in a prison or a jail. And you'd have no running water, but you're also issued particular clothing that you're allowed to have. The only other thing in that cell is that blue mat that you see there. The New Orleans version of solitary looks, of isolation cells, I'm sorry, looks a little different. And here I have a short clip of what these isolation cells look like. They are even smaller than the solitary cells above. They do have a toilet and running water, and usually it is just the lower bunk that you can see. This is on a side hallway, so it is not part of the main prison. And so again, isolated from sound, isolated from sunlight, not knowing what time of day it is, for example, or whether it's even cold or hot outside. And again, the solid steel door with just the view hole for checks. But again, we've had a few deaths in these cells as well, in part because of the lack of visibility and supervision. So I've mentioned a little bit the deprivation that happens, but I want to talk just a little bit more about that mental health impact. And so what you'll see on the top is the underside of a bunk in a solitary cell. And there, the person who was in that cell last used toothpaste in order to keep track of the days, how long they had been in there. And then you can see on the left, they've started writing down the various months, right? And so this inability to keep track of time, to lose your sense of self in space and time, is one of the harder impacts that people, scholars, and like Craig Haney, for example, have written about, and that courts have discussed when they have found certain types of solitary confinement to be cruel and unusual because of their duration, for example. Here on the bottom is the view from inside the isolation cell in Oslo, Norway, outside. And it was interesting in talking to those prison authorities, they said we don't want them to lose complete track of time. And so the only thing that they actually visually can observe, right? The entire cell is a blank slate. It's surrounded by an envelope. And the only thing that they can see is actually one clock. So I want to turn to some of these healthcare challenges that I just discussed when I was talking about the lack of sense in space. But it also poses challenges for how we deliver healthcare behind bars. And so in a Louisiana study, we found that there are significantly high needs throughout the prison population. But when we think about what happens for solitary, we know that those needs are even higher. Second, there are challenges in terms of how you access and then use that service. Here as well, sick call is conducted by the side. And then on the administrative front, what we know in Louisiana is that we allow for doctors who do not have unrestricted licenses, i.e. they've been disciplined and are prevented from working in other types of facilities, that we allow them to practice in facility as well. Last, I just want to turn to the rates of suicide. And here in Louisiana, we found some shocking results that found that 43% of our suicides are actually happening in solitary confinement when it is in a jail. It is less so in prisons and not at all in private facilities. Moreover, for the 4 juvenile suicides that we have, we saw that there were 3 juvenile suicides, 2 out of the 3 occurred in solitary. The last thing I'd like to leave you with is just understanding this similarity over time. So in 1972, Red Hat was closed, and this is the cell on the far left. In the middle, you can see Camp J, which was closed in 2018, but reopened for COVID. And then finally on the right, a currently open cell, and how they all look similar. So I hope that this is helpful for you in understanding the presentations that follow. And I hope that you have a greater sense of urgency in understanding what happens behind bars, particularly when it happens in solitary confinement. Thank you.
Good evening, everyone, and thank you. I'm so grateful Christi for convening this event, and it's a particular honor to be a co-panelist with Professors Armstrong and Stinneford, who are two incredible scholars and very much giants in this field. Listening to Andrea's or Professor Armstrong's chilling presentation about the reality of solitary confinement, two questions that might be on your mind are: how long can this go on for, and how is it legal? In terms of how long it can go on for, there are people in the United States for periods of solitary confinement in conditions like what Professor Armstrong has described for 30 years in certain rare cases. A 2018 study found that about 2,000 prisoners had been in solitary confinement for 6 years or more in the United States, which leads to that second question: how is this legal? And what I'd like to do is describe the legal landscape that countenances these practices briefly, and then turn to the contrasts between the current legal landscape and some of the real restrictions and restraints that existed on solitary confinement in the early years of the Republic, and particularly at the Walnut Street Jail, which is an institution that stood literally across the street from Independence Hall in Philadelphia in the 1790s. The short answer to how is this considered legal is under federal law. How is it that if there is an Eighth Amendment against cruel and unusual punishment and a due process right to reasonable procedures that prevent the imposition of punishment without sufficient justification and rigorous procedures, the reason it's possible, in short, is that federal courts, as directed by the U.S. Supreme Court, are extremely deferential to the decisions of corrections administrators in all aspects of prison life. And that includes both the procedures that result in people being placed in solitary confinement, as well as the substance of how long and can you be held there, and what sort of proportionality is required. Essentially, so long as because of concerns about federalism, because of concerns about meddling in prison affairs, where judges are believed not to have institutional competence and expertise, what has developed is a largely laissez-faire regime in which prison administrators can do close to what they want when it comes to solitary confinement, and can expect that, except in cases that courts find truly shocking or beyond the pale, there will be a huge deference to the judgment of prison officials as to who needs to be in solitary confinement for how long and what the processes are to get there. One of the points that my scholarship has emphasized is how radically different this is from the regime that existed in the early years of the United States. Solitary confinement essentially began in the United States shortly after the United States itself was founded as a nation. when solitary confinement units were created in the Walnut Street Jail in Philadelphia. The idea of solitary confinement, ironically, really came out of a sense, at least in part, of humanity and lenity, and was accompanied by a great restriction in the crimes that could result in the death penalty. Both imprisonment generally and solitary confinement specifically were viewed as humane alternatives to the death penalty, and as the use of the death penalty and as the crimes to which it could be applied decreased, incarceration and solitary confinement increased as essentially the other game in town, so to speak. But as it was originally conceived, solitary confinement was to be of relatively short duration. And so, for example, Benjamin Rush, who was one of the leaders of the Pennsylvania Prison Society, which pushed for these limitations on the death penalty and the use of solitary confinement, believed that it should be tightly controlled by courts, that it should not be, as it currently is, essentially something that prison administrators do because they think that a particular prisoner has disciplinary problems or presents some kind of an administrative or management or challenge, and so let's throw that person in solitary confinement. The idea was that this was a form of criminal punishment, just as the sentence to incarceration was itself a form of criminal punishment, and just as the length of incarceration was to be calibrated to the severity of the crime, so too was the length of solitary confinement to be calibrated to the severity of the crime as a more severe and extreme sanction. And so Benjamin Rush wrote that the nature, degrees, and duration of the punishments, and this included solitude, should be determined beyond a certain degree by a court properly constituted for that purpose. The Justice Bradford of the Pennsylvania Supreme Court, who was a leading reformer when it came to prisons, wrote that solitary confinement should occur only in intervals of roughly 20 to 30 days. And so when a regime of solitary confinement was created through Pennsylvania statutes to operate at the Walnut Street Jail, prison administrators could impose solitary confinement for only 2 days without getting approval from prison inspectors who would come and review the administration of the prison and ensure, in theory, the decency of the prison. They can only do it for 2 days with the line prison officials, including the warden. And even with, if you had the assent of the inspectors and the mayor of Philadelphia, prison administrators could only impose solitary confinement for up to 15 days. And so it was a court in meting out the initial criminal sentence that had the power to impose solitary confinement. And according to a 1794 law in Pennsylvania, the length of solitude had to be between 1/12 and 1/2 of the entire length of the sentence. My review of the records that are available of sentences indicates the judges tended to sentence on the low end of that range. And while the statutes contemplated that solitary confinement in some cases could even go on for life in the case of someone who essentially committed first-degree murder and then was escaped and then committed first-degree murder again, it was used in very rare circumstances for long periods of time, as late as the 1827 and 1832. I found a couple of sources suggesting that in Pennsylvania, no one had actually been in solitary confinement continuously for more than 16 months, which is a shockingly long time to be in solitary confinement, having just witnessed what Professor Armstrong presented. It's mind-boggling to think of enduring that sort of treatment for 16 months. And yet, in contrast to the way solitary confinement operates today, 16 months, 16 months is not an uncommon amount of time to be in solitary confinement today. As I mentioned earlier, recently, there were as many as 2,000 people who had been in solitary confinement for 6 years or more. And so the modern regime of judicial deference, in which solitary confinement is principally viewed as a bureaucratic or administrative function to be carried out by prison officials with really minimal and deferential judicial supervision, would have been quite unthinkable. It was a system in which prison administrators had very little discretion except over very short periods of solitary confinement, where punishment was tied not to one's behavior or conduct in prison, but to the severity of the original crime, and where the sentencing practices of judges at the time, while by no means lenient, and sometimes resulting in the lengthy sentences of up to 16 months that I've described, really paled in comparison to the sort of extreme solitary confinement periods in which years on end in solitary is rather common, and decades in solitary confinement is possible. So we've really come quite a ways since the original creation of solitary confinement as an institution in the United States at the Walnut Street Jail. I'll leave it there and look forward to the questions and discussions. Thank you.
Hi, okay, I've been instructed just to jump right in once David was done, so I am doing so. Let me know if you have trouble hearing me. So I'm going to try and do a couple things in just a few minutes, and probably more than I can do well in that time period, but that's what Q&A is for, I guess. I want to talk a little bit about the Eighth Amendment and whether solitary confinement is a cruel and unusual punishment. And I also want to talk about how that relates to the history of solitary confinement. So just very briefly, the dominant approach to the Eighth Amendment since certainly since the 1970s and maybe even since the 1950s has been what's called the evolving standards of decency test, where we sort of ask, is there a current societal consensus against a given punishment? And if there is one, then maybe it's cruel and unusual. And that's a very problematic test for all sorts of reasons. One of which is that, of course, rights are supposed to protect us from public opinion when it turns against us, but the societal consensus test seems to work the other way. Another problem, as Professor Armstrong noted, is that because suffering in prison is hidden from public view, including suffering in solitary confinement, it's very hard for the public to have a real sense of what that suffering is and to get a real sense of whether it's cruel and unusual. I'm going to argue that that a better approach, it's something that I've argued over the years, in this case would be the original meaning of the cruel and unusual punishments clause. And I'm just going to have to assert it. I don't have time to prove it to you, but my assertion is that cruel and unusual under its original meaning means unjustly harsh in light of longstanding prior practice. That is, unusual means contrary to long usage. It's using the tradition of punishment as a whole as a standard for measuring whether a given punishment is cruel and unusual, whether the pain it inflicts is harsher than society should tolerate. And now, in light of that meaning, I want to look at solitary confinement, because people who defend solitary confinement sometimes do so on the ground that it's been around in one way or another since the founding. As David pointed out, the Walnut Street Jail instituted it as an experiment to try and further really humane goals for punishment. But I want to talk about what happened after that experiment started. So the solitary confinement experiment was very, very popular in the 19th century for several decades. And many, many states followed it or employed it. But over time, people started noticing certain things about what happened to those who go into solitary confinement. In particular, you remember the original theory was that if you put someone alone in a room, maybe with a Bible, some time to reflect, then that's going to be good for them because it keeps them away from other criminals who might have a bad influence on them. And it also may lead them to reform. But over time, what was learned was that when you put someone alone in a room by themselves with no one to accompany them, what tends to happen is they go insane. They develop auditory hallucinations. They lose track of time. They become depressed. They experience very, very extreme emotional suffering and often try to take their lives. And Professor Armstrong noted that that's still a problem today. Very high proportion of suicide attempts in solitary confinement, especially in jails, less so in prisons. I suspect that's because there's more security typically in prisons than and fewer opportunities to commit suicide in jails. But the effects are very, very harsh indeed. And I want to give you just an example, one example from the 19th century. Charles Dickens visited the Eastern State Penitentiary in Pennsylvania, which was the successor to the Walnut Street Jail. And he found that it was horrifyingly oppressive. I'm just going to read you a kind of a long quote from him. He wrote, "I believe that very few men are capable of estimating the immense amount of torture and agony which this dreadful punishment prolonged for years inflicts upon the sufferers. And in guessing at it myself and in reasoning from what I've seen written upon their faces and what to my certain knowledge they feel within, I am only the more convinced that there's a depth of terrible endurance in which none but the sufferers themselves can fathom, and which no man has a right to inflict upon his fellow creature. I hold the slow and daily tampering with the mysteries of the brain to be immeasurably worse than any torture of the body. And because its ghastly signs and tokens are not so palpable to the eye and sense of touch as scars upon the flesh, because its wounds are not upon the surface, and it extorts few cries that human ears can hear, therefore the more I denounce it as a secret punishment which slumbering humanity is not roused up to stay." Okay, I think that's a really wonderful sort of description of what solitary confinement is really like. And what happened historically was after the initial vogue in favor of solitary confinement, where many states adopted the practice, once people realized how horrible the effects were, it was abandoned and fell largely out of usage in the United States by about the 1870s. And it fell so far out of usage that by 1890, the US Supreme Court said, this punishment is too severe for the American system. We simply don't use it. And it largely disappeared from view for about a century. It was, I think prison wardens probably still used it in a kind of underground way, but it was not a visible part of the system for a long time until we got to the 60s and 70s, and especially 1980s, when as a result of prison overcrowding, Supermax was invented as a way of controlling prison populations. And Supermax has been very popular among state legislators and law enforcement officials. Over 40 states now use Supermax. And as you've heard, thousands and thousands of prisoners are subjected to extreme solitary confinement, with several thousand of them for well over a year. There are some who've been in solitary confinement for over 3 decades. Now, and by the way, the modern empirical literature confirms what we learned in the 19th century, that if you put someone, they've done studies on the effects of solitary confinement, and they show that, when a typical person goes into prison, they initially experience intense anxiety and depression, but that tends to alleviate over time for most people, and their happiness level returns to something closer to what it was before they went to prison. But if you put someone in solitary confinement, all the measures of happiness and psychological well-being become stressed, they go down, and they continue to go down. They never recover because it's so intensely stressful and lonely for people who are put in it. Now, what does this tell us from an Eighth Amendment point of view? Well, if we are looking at it purely from the evolving standards of decency perspective, it would actually be hard to challenge the constitutionality of solitary confinement because, of course, as I told you, it's very popular. A supermajority of states have adopted solitary confinement, right? Prison administrators love it. And of course, the public isn't really aware of the suffering. The public thinks, well, it's all Hannibal Lecters, right? They don't realize that you can go into solitary, even prolonged solitary, for simply breaking rules, for being a troublemaker, for being a gang member who won't reveal the identity of other gang members in prison, et cetera. So the public's not roused against it. And so from the evolving standards of decency point of view, it's very hard to challenge. But if we look at it from the perspective of original meaning, we can say, look, this is not a punishment that has ever become part of the tradition. What it really looks like is a repeated failed experiment, right? We tried the experiment for humanitarian reasons in the 19th century. It did not work out, and it was abandoned. It was then repeated in the 20th century for purposes of maintaining prison order. But once again, we're seeing the same terrible effects. So it's not part of the tradition. If we compare the effects of solitary confinement to the effects of imprisonment generally, it's quite clear that they're very much harsher and impose a great deal more suffering than prison does generally. And so I think we can say from the perspective of original meaning that solitary confinement is cruel and unusual. So thanks. So that's all I got for this presentation, but I'm happy to take questions.
Well, thank you all for really wonderful insights into it, from the concrete realities that Professor Armstrong shared with us to the scholarship of both Professor Shapiro and Stinneford with respect to the practice. So I want to just have the panel discuss a little bit of the distinction in arguments. And I was going to address this to Professor Armstrong to talk about the two attacks we have here on solitary confinement. Professor Shapiro is attacking it in that at least part of his argument is that it requires a judicial finding. We have another point of view, and that's Professor Stinneford's perspective, that this is an experimental punishment and therefore is prohibited as cruel and unusual under the Eighth Amendment. Professor Armstrong, if you could comment on those two approaches.
Yeah, so I mean, I think what we are wrestling with is how did we end up with this juggernaut of, what the Pope has described as torture, right, as a common and everyday practice. And so I think the original meaning approach is likely to appeal to certain Supreme Court justices, right, who have emphasized that approach in terms of how they look at what our constitutional rights and in particular our individual rights are by examining our tradition and history. But I think Professor Shapiro's approach, on the other hand, of looking at it in terms of its historical prevalence and reasoning also helps us to understand how far away we have gotten from the initial impetus around solitary confinement. And that's going to appeal to a different set of justices. And so I wouldn't say that they're necessarily contrasting arguments, but instead that they're going to reach different audiences and decision makers who are actively looking at conditions of solitary confinement and challenges across the nation.
I'm going to ask now if Professor Shapiro and Stinneford could also sort of talk about procedural versus substantive arguments with respect to solitary confinement. And sort of jumping off the same points I was making with Professor Armstrong, what is the procedural argument with respect to there must be a judicial finding, and that is one of the arguments, Professor Shapiro, you raised, versus something as violative of the Eighth Amendment because it is cruel and unusual. Professor Shapiro?
No, I'm sorry. Yes, sorry. What I was starting to say was that that the procedural approach and the substantive approach are not in any sense mutually exclusive. The procedural approach under current law principally arises under the Due Process Clause, and the theory is that certain procedures have to be followed in order to be placed in solitary confinement, whereas the Eighth Amendment cruel and unusual approach says that solitary confinement is categorically impermissible, either for a certain categories of people, such as those who have mental disabilities, for whom solitary confinement may be especially painful and harmful, or for or juveniles, or that solitary confinement for particular lengths of time constitutes cruel and unusual punishment as to anyone. And then there is also an sort of an as applied challenge that when one is being punished for a disciplinary violation in prison with solitary confinement, that the period imposed is unreasonably long as compared to the gravity of the disciplinary violation. And typically, wearing my litigation hat when a challenge to someone's placement in solitary confinement is brought, there's both a procedural due process challenge that goes to whether appropriate checks and balances were in place to make sure, as a matter of procedure, that this person in fact ought to be in solitary confinement. And then also in the same case, an Eighth Amendment challenge based on one of the sort of substantive claims that I laid out just a few seconds ago.
So, Professor Stinneford, I understood your argument in your Notre Dame law review, experimental punishments, to be that solitary confinement is both cruel and unusual. Am I correct in the understanding of that article?
Yes, and by the way, I saw a note that people couldn't hear me too well during my presentation. Can you hear me okay? I can't see most of you, so I don't know if you can hear me or not. But I'll assume you can. So two things. First, I'd like to address briefly the procedural point that Professor Shapiro makes. I think it's super important. As he pointed out in his article and in his talk, I mean, there's at least two really important implications. If we recognize that solitary confinement is significantly harsher than a typical sentence of imprisonment, so that it counts as a separate punishment over and above imprisonment, that implies that as a procedural matter, you should not be able to impose it unless a judge imposes it as part of a penal sentence after a conviction for crime, right? And that's his evidence from Walnut Street Jail tends to support the notion that that's how it was thought of. And as I mentioned earlier, there's a US Supreme Court case from 1890 where the Supreme Court says that very same thing, that you can't impose, after someone's given a certain sentence, you can't then impose solitary confinement on top of it if it wasn't previously authorized by a penal statute and imposed by a judge. And so when we see prison administrators doing it on their own authority, that violates the procedural provisions in the Constitution, such as the Sixth Amendment, at least arguably. The other point that David made, which I think is really important, Professor Shapiro made, which is proportionality. That typically when a judicial sentence happens, the punishment is supposed to be proportionate to the offense. But because solitary confinement is imposed by prison administrators based on their desire for prison order or discipline, you can have even very minor offenders given very long periods in solitary confinement simply because the wardens don't want to deal with them because they're troublemakers. And so that's that really violates notions of proportionality. And then finally, yes, I do think that it's cruel and unusual. The two terms actually work together. Cruel means unjustly harsh, but how do we tell whether something's unjustly harsh? We tell it by comparing it to the tradition. So if it's unjustly harsh in light of longstanding prior practice, then it's cruel and unusual. And I think the history of solitary confinement shows that it meets those criteria.
Professor Armstrong, we have some questions from our audience, and I'd like to start off first with Betsy Clark's question. Have other developed nations, including Norway, where you visited, used international concepts of human rights and human dignity to put more limits around solitary, both length, conditions, and what conduct can lead to solitary?
So what we've seen on the international front is a set of rules. They're known kind of familiarly as the Mandela Rules. And those do attempt to limit the length of time that a person can be put into solitary, as well as to guarantee a bare minimum of healthcare, and visitation and access for those people who do in fact happen to be in those conditions or who are sent to those conditions. To my knowledge, it does not limit the reasons or the conduct that might lead to a stay in solitary. But I do think it's important to note that, it is a common disciplinary punishment for all types of conduct. And so all of these prisons and jails have internal disciplinary codes, refusal to obey an order, refusal to work, circulating a petition. The list is quite long, and in many cases, disciplinary segregation is a possible punishment, whether for 1 day, for 1 week, for 1 month, or for an extended period of time, depending on the type of conduct. And so it can be nonviolent conduct, it could be violent conduct, but it's also conduct that can be subject to interpretation by the prison guards. So, the speaking with discourtesy to a correctional officer can start to build a disciplinary history, and that depends solely on the correctional officer. When I think about Norway in particular, what's interesting is they're the parliamentary ombudsman, the person who was responsible for, looking at these different facilities and reporting to the legislature, issued a report in 2019 talking about the prevalence of solitary confinement throughout Norwegian prisons and the difficulties that posed. And so while Norway has made incredible strides in making changes to the culture behind bars and to lessening the punitiveness aspects of certain areas of the prison, in this area, they have not necessarily been a leader. And so it is something that we see countries around the world still struggling with, which is how do you preserve discretion for officials to manage the disciplinary conduct of people who are inside, but also limit the types of punishments that they're allowed to impose.
We have another question from Colleen Lahane, and I'm going to ask Professor Shapiro to comment on it. She says, in my understanding, it is a common practice now. So what is being done to change this practice, if anything? Legally, otherwise, activism? She says she's not sure what the approach should be.
There are a lot of approaches being used, and Professor Armstrong in particular probably is done a huge amount to really shine a light and expose publicly some of the horrors of this practice, and may be best suited to speak to that. There's a lot of self-advocacy that people who are incarcerated engage in, including hunger strikes in response to long periods of solitary confinement. There is a number of different models of litigation, some founded on a procedural approach, some founded on one of the various substantive Eighth Amendment approaches, whether it's about the duration of solitary confinement or the use of solitary confinement on a particularly vulnerable population. And there have been a number of state legislative efforts to restrict and limit the length of solitary confinement and or the populations who can be subjected to it. So there's really been a movement to limit it on all sorts of fronts. I do think that one thing that is heartening, although it is no one would suggest that there has been overwhelming success or anything close to what needs to happen. But I think that 10 or 15 years ago, people barely knew what solitary confinement was, and I mean, in terms of the kind of public at large, it was and in the media was not that frequently discussed. It certainly has become a much greater focus of discourse and criticism and protest than it had been 10 or 15 years ago. I can say that for the group that I direct within the MacArthur Justice Center, the Supreme Court and Appellate Program, we have recently been investing more in state court appellate litigation on the prison conditions front, with the idea being that the Supreme Court has become more and more hostile and likely will continue to be hostile toward kid conditions claims. There was a period of hope where Justice Kennedy had authored an opinion indicating that he was open, as then the swing justice on the court, to substantially restricting solitary confinement. That window of optimism for real change in the federal court system, I would say, has largely passed. And so the strategy for new ground in theory, litigation wise, I think is likely to be state court focused.
I'm going to turn to Professor Stinneford for a different take on the question that Betsy Clark asked in terms of the international approach or concepts of human rights and human dignity. Is it possible that the religious approach, which perhaps has a more robust notion of human dignity and also a sense of what we owe our fellow human beings and that we owe them humane treatment, is that bring anything to this question of solitary confinement?
Thanks. I mean, I think it's yes and no, right? So the yes part is simply that I think people, many people in this country are people of faith whose faith commitments affect the way they think about their fellow human beings, right? And who strive to see even those who are convicted of serious crimes as fellow people deserving of humane treatment and possessed of dignity, whatever they did. And as Professor Shapiro was discussing, if litigation strategies are not currently as attractive, although I'm not sure I'm as pessimistic as he is, but maybe I'm just naive. I think we don't yet know what some of the new justices on the court are going to do about this issue. But in any event, if litigation is not a great strategy, then political action, right, might be the best way to go. And bringing our religious commitments to the table may be a way to try and get the public behind some real reform. The no part of my answer is simply that you can't really make explicitly religious arguments in court. It's not, we do have an establishment clause, and so our arguments about the legality of solitary confinement have to be based on positive law, not on religious commitments directly. Although I will say one sort of caveat to that is that the notion of sort of how shall I put it, of long usage, the notion that punishments that violate the tradition are cruel and unusual, is based ultimately on a natural law view of the world, which of course has a religious foundation to it, right? There's this notion that there really is a right and a wrong out there. There really is a punishment that's unjust because it's unduly harsh, it's inconsistent with the dignity that all people possess. And that notion that in reality, there is such a thing as justice, and that in reality, people possess dignity apart from what other people think of them, is probably a religious notion and its foundation. But in practice, of course, what one argues about is not those questions, but rather the implication of them, which is that if we have a tradition of how we've treated people, how does this new punishment comport with that tradition?
Thank you. I'm going to turn to Professor Armstrong for two questions, one from David Swanson, which I know you've addressed him as to the answer, and also David Zins. The first question is, what's the proportion of female to male use of solitary? And then secondly, speaking of proportionality, how should someone who has committed a violent rape in prison, murder in prison, or any other type of aggravated assault, either on another prisoner or guard in prison, be treated to keep such behavior from happening again?
So as to the first, and I'm not sure if I understood the question correctly, but I did want to say that there isn't a difference in treatment necessarily between women and men in terms of their experience of solitary confinement. What we do know is that women are a much smaller proportion of the population. And yet we also know from research that's been conducted by the Vera Institute for Justice that women are uniquely kind of vulnerable and also experience greater sentences often in that disciplinary process than their male counterpart would have. And so that raises questions about whether women are also disproportionately represented within the solitary population. There have been limits on that. In particular, there's been efforts to limit the use of solitary confinement for pregnant women in particular, as well as other categories such as those with serious mental illness, which really is an analog to what we've seen in the death penalty realm, where many of the litigators worked to limit the death penalty in part by excluding certain populations. So excluding juveniles, for example, from the death penalty, or limiting the types of crimes for which it can be imposed. And we're seeing similar trends in solitary litigation as well. On the proportionality front, the name of the game is prevention. And so there's robust work and evidence around housing classification decisions and how instrumental those can be on running a safe and secure and an orderly facility. It is not surprising that in conditions of scarcity, that people act out and that they may in fact become violent, and in part to perhaps claim resources or power in a way in one of the few ways that is accessible to them. And so it is about prevention. It's housing classification, it's intake assessments. The Prison Rape Elimination Act, for example, recommends and has as one of its guidelines whether they in fact do intake analyses on who might be a victim because of their stature or because of their sexual orientation, for example, and who was more likely in terms of a risk assessment to be a predator. And all of those are tools that correctional professionals have at their disposal. And so I understand that there is a separation argument that needs to happen after that violence has occurred. But I do question whether we really put enough effort into our prevention exercises first.
Thank you, Professor Armstrong, Professor Shapiro, and Professor Stinneford for a very stimulating evening's discussion on a very important topic. And I think we all come away from this believing that to deprive any person of human company deprives them of their humanity. I'd like to join our audience in expressing appreciation for these wonderful presentations and invite you all to join us again a week from tonight for a discussion that will be occurring at Seattle University on justice and peace, a radical reconsideration of public safety. And 2 weeks from today at Loyola University and online, both of these are hybrid events, on The Rage of Innocence, Chris Henning's new book. If you would like to know more about the programming of Lumen Christi, go to lumenchristi.org and tell everybody about the programming, especially of the Catholic Criminal Justice Reform Network. Thank you, everyone, and have a good night.